welcome to the deep dive. You brought us something really interesting today, the evidence ordinance.
Yeah, it sounds a bit heavy, maybe.
Yeah.
But it's basically the rule book.
The rule book for, like, how courts decide what's true. And that impacts all of us, doesn't it? I mean, it shapes how justice is served.
For sure.
So our mission in this deep dive is to unpack some of the core ideas, show how surprisingly relevant they are to understanding how, well, legal truth gets built.
Exactly. You were curious about how legal proceedings actually determine what happened, right? And this ordinance, well, it's the key. Think of it as getting a backstage pass to the logic behind legal proof.
Okay.
We'll look at what counts as a fact in the law's eyes, and maybe even more importantly, how its relevance is decided.
Okay, so let's start right there. What does the ordinance actually mean by a fact? It seems wider than just, physical things.
It is, yeah. It definitely includes physical stuff like objects in a certain place or someone hearing or seeing something specific, obvious things.
But this goes further.
It goes into what's happening inside our heads. Any conscious mental state. The examples they give are pretty interesting.
Like what?
Well, having an opinion or a specific intention, acting in good faith, or fraudulently.
So internal stuff, even the words someone speaks.
Yes, these specific words. Or just being conscious of a sensation, a feeling. And get this, even your reputation is considered a fact.
Wow. Reputation is a fact. That's interesting.
It is, isn't it? What's fascinating, I think, is that the law acknowledges these internal subjective things as factual elements.
Yeah.
Even though they're, not as easy to pin down as a broken window.
Right. It really highlights the challenge, I guess, trying to piece together what really happened when motives and intentions are just as important as the physical evidence.
Exactly.
Okay, so just because something is a fact, that doesn't automatically mean it's allowed in court, right? That's where relevant comes in.
Precisely. That's the next crucial step. The ordinance is very clear. One fact is relevant to another only if they're connected in specific ways the ordinance itself spells out.
It's about drawing those lines,
Yes.
the connections.
Yes, it's all about those essential connections between bits of information.
Which brings us to facts in issue. That sounds important.
It is critically important. Think of these as the make or break points of a legal case.
Make or break. How so?
Well, these are the facts that, either on their own or maybe combined with other facts, absolutely determine whether a legal right exists or a liability or maybe a disability. The core things the case is trying to decide.
Okay, gotcha. The ordinance gives examples, right? Like in a murder trial.
Yeah, really clear ones. A fact in issue could be, did the accused actually cause the death?
Okay.
Did they intend to cause death? That's another one. Or was there significant provocation? Or even was the accused, not legally sane at the time? These are the absolute central questions.
So the entire case revolves around proving or disproving these specific things.
That's it, exactly. These facts in issue are the legal battleground. Everything else, all the evidence we talk about, has to relate back somehow to proving or disproving these points.
That's a really crucial takeaway then. It keeps things focused.
It does. The whole evidence process is laser focused on these facts in issue. Anything else brought into court must connect back to them somehow.
Stops it wandering off topic.
Right. It prevents the proceedings from getting lost in, irrelevant details, keeps the focus squarely on what the court needs to decide. It's a mechanism for efficiency, really, making sure decisions are based on stuff that actually matters to the legal questions.
Okay, so we have facts, and the really core ones are facts in issue. Now, how does some other fact become relevant enough to be brought in? The ordinance details these connections.
It does, yeah. It goes into quite a bit of detail. One key area is Section 6. That talks about facts forming part of the same transaction.
Same transaction. Well, what does that mean exactly?
It's about actions, words, events that are so closely linked to a fact in issue that they're basically seen as part of one continuous sequence, one unfolding event.
Even if they happen at slightly different times or places.
Yes, exactly. Think of transaction here like a connected series of events, almost like scenes in a movie building the story.
Right.
Each bit is linked to the main event.
Okay, so an example.
Well, the ordinance suggests if someone's accused of murder by beating,
right,
then anything said or done by the accused or the victim, or even bystanders during the beating, or maybe immediately before or after it, that could all be relevant. It's all part of that immediate sequence.
Makes sense. It paints the picture.
It does. Another example they gave is an armed uprising, like waging war.
Okay.
Even if one specific person wasn't involved in every single violent act, those other acts could still be relevant to prove the bigger transaction the overall plan of waging war, as long as they were part of that same general effort.
Got it. So Section 7 broadens this out a bit more.
Yes, slightly. It brings in facts that are the occasion, the cause, or the effect of facts in issue or relevant facts.
Occasion, cause, effect. Yeah.
Or facts that provide an opportunity for them to happen. So it casts a slightly wider net.
So sticking with the murder example.
Right. Imagine finding marks on the ground at the scene. Clear signs of a struggle.
Okay.
That struggle isn't the murder itself, but it could be relevant as an effect of the altercation that led to the death.
Right. Shows what happened.
Or, say someone's accused of poisoning. The victim's state of health before any symptoms showed up. That's relevant. It establishes the baseline, the occasion, before the fact and issue occurred.
Or maybe the opportunity.
Exactly. If the victim had a predictable routine, maybe that created a specific window and opportunity for the poisoning to happen. That routine could become relevant too.
Okay, that makes sense. Then there's Section 8, motive and preparation.
Ah, yes, motive and preparation. This is where we start digging into the why.
The psychology behind it.
Sort of. Any fact that points to a possible motive or shows someone prepared to commit the act in question the fact in issue, or even another relevant fact that becomes important.
And it also covers behavior.
Yes, the conduct of the parties involved, or maybe their agents, if that behavior is influenced by or influences a fact in issue.
But there's a catch with statements.
There is. It's crucial. Generally, just repeating what someone said isn't considered conduct under this section unless those words directly explain their actions.
So saying I was mad at him might not cut it.
On its own, probably not under Section 8.
Okay.
But saying, I bought this knife because I was mad at him, now the statement explains the preparation of buying the knife, so it could be relevant.
Okay. Examples from the ordinance.
They give us some good ones,
Right.
like maybe the accused had committed a previous murder and the current victim knew about it and was blackmailing them.
Ooh, strong motive there.
Definitely. Or simply procuring poison of the same, maybe unusual type that was eventually used. That suggests preparation. Even something like running away, absconding, after getting a warning letter about the crime. That's conduct influenced by awareness of the situation.
Okay. And the last one for relevance in this chunk was Section 10, conspiracy.
Yes, conspiracy. This deals with situations where people are working together towards an illegal goal.
Like a gang.
Could be, yeah. If there's a reasonable ground to believe a conspiracy exists, that two or more people have agreed to do something illegal, then things change.
How so?
Anything said, done, or even written by one of the conspirators, if it was done to further their common plan, well, that becomes relevant evidence against all the others involved.
Even if the others weren't there or didn't know about that specific thing.
Correct. Even if they were completely unaware of that particular act or statement at the time, if it was done in furtherance of the shared plan, it links them all.
So planning a robbery example.
Yeah, perfect. One person buys the getaway car, another scouts the bank, a third gets the weapons. Even if they do these things separately, and maybe don't even tell each other every detail, each action is relevant to proving the overall conspiracy against all of them, because it's all part of executing the agreed-upon plan.
The ordinance has an example, too.
It does, a pretty large-scale one about waging war. Imagine different people, different places. One buys weapons, another collects money, someone else recruits people, another distributes pamphlets.
All separate acts.
Separate acts, yes. But if you can reasonably show they all tie back to a common intention, a plan to wage war, then each of those individual actions becomes relevant evidence against everyone involved in that conspiracy. It shows the plan existed and who was part of making it happen.
Wow. Okay. So we've covered these foundational rules for what a fact is and how connections make other facts relevant to the main facts in issue.
Right, through things like being part of the same event, or cause and effect, or showing motive, or being part of a conspiracy.
But what about facts that don't seem relevant at first? Can they ever become important?
Yes. Section 11 deals with that. It's about situations where facts that might seem, totally unrelated on the surface can actually become relevant.
How does that work?
Well, there are two main ways in Section 11. First, subsection A says if a fact is inconsistent with a fact in issue or with another relevant fact, then it becomes relevant itself.
Inconsistent. So like it contradicts something.
Exactly. It's about creating doubt, showing contradiction in the story being presented. If one fact makes another fact less believable, it's relevant.
Okay. And the second way, subsection B.
Subsection B is broader. It says any fact becomes relevant if either by itself or maybe combined with other facts, it makes the existence or non-existence of a fact, an issue, or a relevant fact, highly probable or highly improbable.
Whoa. Highly probable or improbable.
Yeah.
So even if it's not a direct contradiction, if it strongly points one way or the other?
Precisely. Even if it seems quite circumstantial or indirect at first glance, if it significantly shifts the probabilities, the ordinance says it's relevant.
That really shows how layered legal proof can be, doesn't it? You have to look at how everything interacts.
You really do. It's not always direct A proves B. Sometimes it's about building a picture or poking holes in one.
Does the ordinance give an example for this, Section 11?
Yes, a very clear one. Imagine a crime happened in, say, Colombo on a particular day.
Okay.
Now, if you can reliably prove that the person accused was actually in Galley quite far away on that exact same day.
Right, an alibi, basically.
Essentially, yes. That fact being in Galley seems unrelated to the Colombo crime itself. But under Section 11B, it becomes highly relevant because it makes the existence of the fact in issue, them committing the crime in Colombo, highly improbable.
It doesn't make it absolutely impossible. Maybe they traveled fast, but...
Exactly. But it makes it highly improbable. It strongly undermines the likelihood of the fact in issue being true. So that alibi evidence comes in.
Got it. So wrapping up this first part of our deep dive, it feels like we've laid some important groundwork.
I think so. We've seen how the ordinance starts by defining these crucial terms. Fact, way beyond just physical stuff, including mental states.
Right, and relevance, not just any connection, but the specific kinds of connections the ordinance allows.
Like being part of the same transaction, cause-effect, motive conspiracy.
And facts at issue, those absolute core questions the whole case hangs on.
And you've gotten a glimpse, I hope, into how the law carefully looks at how events link together, the reasons behind actions, and even details that seem small but might shed light on the truth.
Yeah, this whole framework of relevance, these early sections we've looked at, it really sets the stage. It's about creating a structured way to decide what information gets considered, aiming for a reliable picture of what happened.
Absolutely. And it's worth thinking about. This isn't just some dusty old legal idea. How do these principles play out today?
You mean with technology and everything?
Exactly. Think about digital evidence. Social media posts, text messages, emails. How might a court decide if a series of tweets are part of the same transaction as a later event? Or could a pattern of online searches indicate motive or preparation under Section 8? It's applying these old principles to totally new kinds of facts.
That's a really interesting angle to think about further, how these rules adapt or if they need adapting.
They're definitely something to mull over.
So look, this deep dive really has just scratched the surface, hasn't it?
Oh, absolutely. The evidence ordinance is extensive. It goes into huge detail on different types of evidence too, documents, oral testimony, what counts as an admission, rules around confessions, lots more.
Right. So if any of these specific areas caught your interest, maybe you're wondering how you actually prove a document is real in court, or what the limits are on witness testimony.
Yeah, or the rules about hearsay, perhaps? Let us know. We can definitely tailor future deep dives to explore the parts of this, well, this fascinating legal landscape that you find most intriguing.